Hello, everyone. My name is Ron Kearns. I'm an elder law attorney. I'm also a registered nurse. I've been, believe it or not, a nurse for 41 years and an attorney for 35 years. So I know I look young, but I started young. So it's kind of funny. My daughter is a registered nurse, and right now. So it's kind of exciting that she's following in Dad's footsteps. My area of practice is what they call estate planning and elder law. Elder law, they're kind of getting away from that term. I think they want to refer to people as older adults. And I'm coming from Massachusetts, so I'm going to talk general about what the law is, but know that my real expertise is in Massachusetts law, although throughout the country, the federal government has, standards. So, anyways, I'm going to talk about estate and long-term care planning. This is going to be educational, and I want it to be informative, and I want you not to be shy about asking questions. So, we'll take it to the next slide. So first of all, I don't have any conflicts, real or apparent. I'm doing this purely what attorneys call pro bono. As a nurse attorney, I love to be able to give educational seminars. I do it in my home state, and I'm very honored to be asked to do this today. It's general information. Don't take this as specific legal advice. Always consult with a local attorney on your specific needs. But hopefully this will spark some interest, and you may say, boy, I have everything in order, or you know what, maybe I have to shore up these areas. And also, one practice tip that I can give you is National Academy of Elder Law Attorneys is a really good place to start to find an attorney that is experienced in estate and Medicaid planning. And I give you their website. I'm a member in Massachusetts, but you can find attorneys throughout the country. That is a really good place to start for an attorney that specializes in this area. In Massachusetts, the legal age for an older adult is 60 years or older. Now, I ask that question a lot to people, and they'll, what's the age of a senior? And they say 65, when you can get Medicare, 62, or 67 when it's the full age of retirement. No, the legal age is different in each state, but in my area, it's 60 years or older is considered a senior. And that's because somebody in my state can access benefits through the elder services, through the local ASAP. So that's a really good nonprofit organizations for you all to have, so that, if you ever need any help, it's a really good place to look for some help. So those are my open remarks. I'm here for purely education. All right, so I'm going to talk about some legal solutions that I think is very important for everyone, especially as we get older. I'm going to talk about some financial considerations, care options. There's some veterans programs out there for all of you that are veterans or surviving spouses of veterans or spouses of veterans. There are some good programs under the VA. I'm going to talk a little bit about Medicaid. Now, Medicaid is a state and federal program where the federal government typically puts half the funds in, and your individual state usually contributes the other 50%. But each state is a little different, but there are some really good Medicaid programs to help get help at home. And a lot of times the rules are less stringent than what we call long-term Medicaid, which is nursing home Medicaid. And I'm definitely going to talk about that. God forbid a loved one needs a nursing home. What are the general rules? I'm going to talk a little bit about that. So and then I'm going to plenty of time for questions and answers. And again, don't be shy on asking questions. Okay. So the program today is designed to increase your understanding of the importance of proper estate and financial planning to support your quality of life. That is the purpose. And hopefully, some of the things I'll talk about will be beneficial to you. This is a busy slide. It's not meant to be that busy. Some of this was supposed to be indented, but I can still explain it. One of the legal risks for people is um, if we are ever incapacitated and unable to speak for ourselves, you need a legal representative. You need somebody to speak for yourself. And typically, for healthcare decisions, if you don't have a valid, what some states refer to as healthcare proxies, other states can refer to advanced directives for healthcare, powers of attorney for healthcare. If you don't have somebody that can make medical decisions for you, then we have to resort to the courts. And that's no fun because going to court in our jurisdiction, it's probate court. And sometimes they're called family courts. They're different in each state, but it's really a family has to petition to be able to make medical decisions. You want to do that well in advance. They're called advanced directives. I want to get a healthcare proxy in place, an advanced directive of healthcare that if I can't communicate a health decision, then I appoint a loved one. And then it's always good to have backups. So in most states, you only can have one primary agent. So um, my healthcare proxy is my spouse, but then I have my children, adult children, as backups. Because what if something happened to my spouse? You want to have comprehensive documents that you'll have trusted decision makers in place, and that's called an advanced directive for healthcare. Very, very important. A lot of people say to me, "I don't." Well, I want to make my own decisions. Of course, absolutely. As long as somebody has capacity or is competent to make their own decisions, the healthcare agent has no authority. It's really like a springing power of attorney for healthcare. If the doctor says I can't communicate a health decision, that activates my healthcare proxy. And now my agent has legal authority to speak for me. And a lot of people think, well, I have a spouse. Can't they legally speak for me? No, actually not, because sometimes the spouse isn't the best person to be the healthcare agent, right? You have that decision. What if a spouse has some medical issues? Maybe it's time to jump to the next generation. So just because you're married doesn't mean your spouse can make medical decisions for you. Um, they can't. You need somebody in writing that's going to make those decisions. Now, conversely, for financial and legal decisions, um, typically it's a durable power of attorney agent, and hopefully you have all those documents in place. Power of attorney is I appoint my spouse and then my children to be able to make financial decisions for me. They can pay my bills, they can access my finances. Obviously, you have to have somebody that you trust because that's a very powerful document. You don't want to put somebody on it that in the back of your mind, whether maybe they can't balance that checkbook, they may have some different issues. You really need somebody that's very that can handle finances and balance that checkbook. Because if you don't have a durable power of attorney and you become incapacitated, then family members and loved ones have to go to court for a conservatorship. Or some people pronounce it conservator. Um, so with its court oversight, and that's time and expense. So we want to avoid guardianships and conservatorships, and it's very easy to do. You just have to have those legal documents in place. Advanced directive for healthcare and an advanced directive for finances, a durable power of attorney. Now, a lot of people ask, what about protecting assets? A lot of people, asset protection, typically when somebody asks that question, they're really referring to, God forbid, if I needed extended care in a nursing home, would I have to spend all my assets on the nursing home? And again, there's nothing wrong with doing that. Some people, that's the best course of action to private pay? Or should I be accessing Medicaid, the federal program, and how do I access that? But more importantly, if I ever needed long-term care, um, should, is there any way I can protect some of my assets? That's a very frequent question. Well, there is. Um, Asset protection generally takes 5 years to work. I think that you all know that, or may have heard of the 5-year look back. Typically, if I needed a nursing home tomorrow, the government would look through 5 years of financial transactions. And they're looking, did I transfer any assets out of my name? Did I give gifts to children? Did I transfer a house into an irrevocable trust? Those are all disqualifying transfers if I don't get through the 5-year look back. So it's very important that if somebody's goal was to protect assets for their loved ones, and typically it's for children, adult children, right, and grandchildren, um, then they do it 5 years in advance. You just have to follow the rules because it is a 5-year look back. So asset protection is very important, but you have to do the proper planning. And how do you protect assets? Well, one frequent way is, and what's the most common asset to protect? Real estate, a house. I get the question all the time, Ron, I worked hard all my life. My house is my biggest asset, like most people, and I really would like to leave it to my children and not have it be encumbered by Medicaid or a nursing home or the state. How can I accomplish that? Well, that would typically the way it's done is by what we call an irrevocable trust. It's I deed my house into an irrevocable trust. I always have a right to live there. Typically, those trusts give me the right to live there, or I have a life estate in the deed or use and occupancy in the house. But it's really not my house, right? It's for the benefit of my two children, my two adult children. And so if I do that, that's considered a transfer in the government's eyes. And after 5 years, it's generally not considered my asset. I've gotten through the 5-year look back. That's okay. It's sanctioned by the government because I did advanced planning. That's one way to do it. And again, I'd have you consult with attorneys that practice in this area in your state. But asset protection, very important. And some clients say to me, Ron, I don't have any children. I have nieces and nephews, etc. Generally, when somebody doesn't have any children, I don't usually recommend protecting assets in an irrevocable trust because it really is a windfall to nieces, nephews, charities, etc. And therefore, I usually recommend you just use your assets for your care and just avoid probate. Revocable trust, irrevocable trust. I've touched a little bit about irrevocable trust. An irrevocable trust is an asset that I technically can't change. That's the word irrevocable. Traditionally, I'm not in charge of that asset. My son, for instance, would be the trustee, and my daughter would be the backup trustee. I may have a right to live in that house, or if it's financial assets like an investment account or cash. I have usually those type of trusts. I have the right to the income, but I don't have a right to the principal. That's for the benefit of my children. So there is some, you do lose control. So typically, if you're going to do that, you have to really trust your adult children. So revocable trust means I can change it. It's for my benefit. Only after I'm gone does it go to my loved ones, my family, whoever I designate. That's a revocable trust. But assets in a revocable trust, a trust that I can change and I'm the beneficiary of, they always count as my asset if I need a nursing home. So my grandmother, who lived to be 100, and honestly, she was very good up until 99 and a half. She used to say to me, Ron, trusts are only for very wealthy people. And I'd say, Grammy, Trusts are for regular people nowadays because the laws, things are very complicated. And I'd explained to her, Grammy, there's a revocable trust that will avoid probate, but it counts as your asset. But then there's a irrevocable trust that protects assets after the 5-year look back. And she'd always say to me, well, don't put all your eggs in one basket. And I'd say, Grammy, I wouldn't do that. Typically, we use two trusts, one that's revocable, and if a client wants, one that's irrevocable. So think about that. There's different types of trust. Do you want both? Do you want just a revocable trust, or do you want to also have an irrevocable trust? It depends on your goal, and there's no right or wrong answer to it. We also have special needs trusts. If you have a child that has special needs situation, typically a lot of times adult children that have some special needs really can't be in control of their assets, or if they got an asset directly through inheritance, they're disqualified for programs they're on, like SSI and Medicaid themselves, or housing. So in the old school attorneys used to disinherit and not leave anything, say disinherit a disabled child. But that's a kind of an old school thought. But the really vision that I have, and most attorneys have, is if somebody has a special needs child, you don't have to disinherit them. You just leave assets in trust for them controlled by your other children, and trust that won't upset their benefits. And sometimes there's adult children that aren't technically disabled or on any special benefits, but they're really not good with money, and their assets really should go into a trust, or they may have gambling issues or addiction issues that it would be disastrous to leave them in inheritance. You can leave it in a trust for them. You don't have to disinherit them. There's family trust that's for your benefit and then your family. All trusts, if used properly, will avoid probate. Now, if any of you had gone through probate, if one loved one's passed away, it's not fun. It's time, it's expense. Most of the time, we try to avoid probate. And really, all probate is the legal transfer of assets from the decedent to their beneficiaries. So if I passed away, how is my house supposed to get into my children's name? How are my assets supposed to go to them? Well, one way is by a will. A will would dictate that. Another way is by a trust. I don't want my kids to have to hire a lawyer and go to probate court. I just want it to be seamless. Then I would probably be thinking about a trust. If anything happens to me, this house is in a trust and it just goes to my children. Then you have to think about what type of trust. Is it irrevocable because I'm trying to protect it from long-term care costs? Then I'd lose a little bit of control, or is it just a revocable trust? Those are things you'd talk to your attorney about. But we do like to avoid probate. What's the poor man's way to avoid probate? Make sure that you update your beneficiaries on your accounts. So for instance, if I have an IRA at work, I want to make sure that I have my spouse, then my children as the contingent beneficiaries. If I have a life insurance policy, I want to make sure I have updated beneficiaries. Sometimes a spouse passes away and they were the named beneficiary of a life insurance or an IRA or some kind of financial account, annuity. And if there's no other contingent beneficiaries, that asset has to go through probate. So I always say the poor man's way to avoid probate is to make sure everything is updated. Keep your life insurance, your IRAs, all those things updated with beneficiaries. And the probate is legal transfer of assets, as I said, from the decedent to their beneficiaries. It's court supervised, and we just like to avoid it because time cost, and it's public. Anybody can go down to the probate court and look at your will. Sometimes if somebody's famous that passes away, people go down and try to steal the will. They want the will because of an autograph. It's original. So usually the court will let you see it, but they don't give it to you, because there are some wills that disappear of very famous people, um, because of the signature is on there. So, anyways, estate taxes. My dad used to always say to me, "There's one thing that's certain in life: death and taxes." And I said, "Oh, that's very pleasant, Dad." But estate taxes is something that you have to consider. Typically, federally, it's not an issue. The federal government raised their amount. You can pass $15 million upon your passing without a federal government death tax. Each state is a little different. Massachusetts is capped at 2 million, which is, in my opinion, a little bit low because real estate and things like that could put you over with other assets. So most states, though, don't have a state tax, which is really good. I think there's only 11 or 12 in the country that have estate taxes. So chances are, unless you're in one of those 11 or 12 states that have them, you don't have any estate tax. So you want to look it up or ask the attorney. Um, it's a nice problem to have. If somebody has an estate tax federally, that means they have a very large estate, and it's a nice problem to have. But there's ways to double that exemption, and it's by way of trust. So you have to see, typically we refer to a tax attorney if somebody had a very high estate, because the tax attorneys can double the exemption to try to make there be no taxes. Okay. Boy, that was a lot. All right. So, but it's important information. So let's talk about some legal solutions. I've gone over these: healthcare proxy or durable power for healthcare. You name somebody to make medical decisions for you. Now, in my state, the legal age of majority is 18. So if somebody's 18 or older in my state, and it's probably most states too, the legal age of majority is probably age 18, um, that they're their own person legally. They can sign a contract legally. They can do their own estate plan. So I think for a lot of young people, if they're 18 or older, they're probably just starting out in life. They don't need any fancy plan, but they should certainly get a healthcare proxy. They should certainly get a durable power of attorney, especially if their parents are paying their health insurance. As I tell my kids, um, listen, you should do a healthcare proxy and a HIPAA and give me and your mother the right to talk to the healthcare. After all, we're paying for your health insurance till age 26. So anyways, but all kidding aside, healthcare proxies, very, very important for everybody to have. If you remember a few years ago, Terry Schiavo case in Florida, a young woman was 28 years old and she was incapacitated. Now, that was a very interesting case. Tragic, very tragic, but she was incapacitated, but she was alive, but in a consistent vegetated state. So not responsive, but she was kept alive by G-tube feedings, and she was transferred to a nursing home. And her parents wanted to keep her alive, and that's understandable, right? An adult child. Her ex-husband said she didn't want that. Now, he wasn't even married to her anymore. She always expressed to me, the ex-husband said, I wouldn't want to be kept alive artificially. So that had to go to court. And in the judge finally, after hearing all testimony, said that we think that her wishes were not to be kept alive, and she was allowed to go peacefully. The G-tube feedings were stopped. So that just illustrates to me that even at a very young age, it's not people that are just older adults. Even at a very young age, in your 20s, people should have the basic documents: a healthcare proxy, HIPAA authorization, even a living will. I almost wonder if Terry Schiavo had a living will that said in her own, and she signed it, that says, I don't want extraordinary measures, then it may have been easier for her parents to let go. That's the way I kind of look at it. Plus, it would be easier for the judge to see, well, in her own writing, She didn't want extraordinary measures. So I just say that example because it was a very tragic case, but really anything can happen to anybody at any age. I think you all know that. Healthcare proxy, HIPAA authorization. HIPAA is a federal law that says anybody that I put on my HIPAA authorization has a right to talk to the doctor, healthcare providers. And so without violating confidentiality rules. A lot of people say, well, I have a healthcare proxy. Why do I need a HIPAA authorization? It's a good question because a healthcare proxy has to be invoked by the doctor. The doctor has to say you're no longer able to make medical decisions before the agent has any authority, including HIPAA authorization. But if you have a standalone HIPAA authorization, if you're ever in the hospital, your son could call, hey, how's my mom doing? Your daughter, whoever you name, your spouse. So we always do a HIPAA authorization along with the healthcare proxy. And don't go crazy. Don't name 10 people. Just name the important people. They can communicate with all the other people, right? Um, Durable power of attorney for financial. I talked about that. Very important. So I consider healthcare proxies, HIPAA authorizations, durable power of attorney. You don't see a living will on there, but I like living wills where you express what your wishes are. Um, Different states have doctor forms that you fill out with the doctor about your end of life wishes. In Massachusetts, we call it the MOLST, Medical Orders for Life Sustaining Treatment, and it's real good. And it's really for people that have serious issues and kind of end of life issues. I think if a really healthy person came into the doctor and said, "I'm going to fill out a MOLST form," I don't know if they would sign it. Um, so at any rate, but living will or a MOLST form, or the federally it could be called a POLST form, but something where your wishes are. I also think those forms are really good as guidance to your healthcare agent. Like, geez, my mom would want this. I mean, she said it right here in writing. I know I'm the one who was appointed the healthcare agent, but I have a little guidance from her. Or my dad would want this, etc. So, and then wills. I always say where there's a will, there's a way, right? A will just distributes your assets upon your passing. And a lot of people, and wills can be changed. As long as you're competent and you have capacity, you can update your will anytime. But a will says how you want your assets distributed upon your passing. Now, a lot of people say to me, Ron, if I have a trust, do I need a will? Well, usually we do both. And the reason being is we hope everything passes by the trust, which incidentally usually says the same thing as the will. Like if I had a will and said I want to leave everything to my spouse and then my children equally, my trust would probably say the same thing. However, I don't want to use the will. I want the assets to avoid probate and go by the trust. But what if I forgot about an asset? I had a bank account, or I had a car, or I had this other financial account, but I forgot to name beneficiaries. It would go by my will. So a will is important at the very least. But if somebody has a trust, we usually want their assets to go by the way of the trust. But they usually say the same thing. And not to confuse you, but because it is a little confusing, there's also a will we call a pour over will. That means I leave everything to my trust. If I forgot about anything, put it in my trust. So I don't say I leave it to my wife and my kids because my trust says it goes to my wife and my kids. So just an idea, there's all different kinds of wills, but everybody should have a will, in my opinion, no matter how simple somebody's estate is, no matter how complex. It's very important to have your wishes in writing. Typically, a will needs two witnesses, and usually it's notarized. Now, what's a deed with the life estate? I don't know if you guys have ever dealt with this, but a deed with a life estate is typically I deed my house to my two children, but I reserve a right to live there. That's the life estate. I'm in charge. I pay all the bills. I have all the benefits of the property. Matter of fact, if I'm mad at my children, they they can't say, well, Dad, I'm on the deed. I have a right to be there. No, I'm in charge. I have a life estate. So I'm the boss. But upon my passing, it passes automatically to my children. We don't need to go through probate. You don't have to use my will. It's not a trust. They're actually on the deed with me. They're not joint tenants. They don't have an equal right. They're subject to my life. It's called a life estate deed. Other states refer to it something different. Florida, ladybird deeds. Um, and so a life estate deed is a very simple thing that people can understand, but it has the same effect as an irrevocable trust. Is that when I do a life estate deed and I give my children some ownership, my adult children some ownership interest, then that that starts the 5 year look back. In the government's eyes, I've started the 5 year look back to protect that property. Very simple, very old fashioned. A lot of clients like that. Now, then we have trusts, which we like also. A trust can be revocable, and that means it's for your benefit. You can change it, you can revoke it, you can amend it. When you pass away, it becomes irrevocable. It can't be changed, and it avoids probate. However, if you needed long term care in a nursing home, God forbid, the revocable trust counts as your asset. Different from an irrevocable trust. An irrevocable trust, I can't change it. I irrevocably give up my rights, and usually my children are the beneficiaries, and usually the children are the trustees. I'm not even in charge of it. But I do have some power. I have a right to live there. If it's a financial asset or the house was sold, I typically have a right to the income. Those trusts usually give you the right to the income or the interest. But the principle is really not under my control, and it's really made for the benefit of adult children. Uh, if I have an asset in an irrevocable trust, after 5 years, it doesn't count as my asset if I ever needed a nursing home. So it's done for asset protection. Those type of trusts can be used on real estate. They can be used family trust. And of course, we already talked about special needs trust. So this is just a little bit, some highlights for you to think about on your own estate plan. Okay. Now, I'm going to check the clock. Okay, we're doing okay. Okay, so Medicare. Medicare is a federal program that pays for what I call, when it's called acute care. And people are entitled to Medicare when they're 65 or older, and they've paid into the Social Security system. Or if you become disabled before age 65 and you paid into the Social Security system and you're entitled to SSDI, you receive Medicare benefits after 2 years from your disability. So Medicare is a very, very good program. It's known as very good insurance coverage. The federal government does a good job with Medicare, in my opinion. It pays for hospital care. It pays for rehab. It pays for home health care on an intermittent and finite basis. But Medicare doesn't pay for long-term care. And so a lot of people say to me, Ron, I went into a nursing home after my hip surgery or my knee surgery, and Medicare paid for it. And I say, yes, I know, but that's not long-term care. That's acute care. That's acute rehab. Medicare paid for that, typically up to 100 days. So I want you to know Medicare is a very good program. It is, they're very efficient, in my opinion, and from what I read on it. And but it doesn't pay for long-term care. That's not what the contract says. Now, there's long-term care. How do I pay for long-term care? Long-term care means I'm in a nursing home. My rehab ended, but I'm not strong enough to go home. I need to stay there. I need that type of care. I need 24-hour care. Typically, that's called custodial care. That means I need help with my activities of daily living. I need help. I need help with shower, getting dressed, transfer out of bed. I need help with walking. I need help with toileting. I need help with feeding. That's called activities of daily living. And typically for a nursing home, if you need at least 2 out of 6 activities of daily living, you clinically qualify. So I have a client that has Lou Gehrig's disease, and he's a Hoya lift out of bed. So he needs all 6 activities of daily living assistance with. He qualifies for a skilled nursing facility, but actually we have him at home with community Medicaid benefits at home, which we're going to talk about. So long-term care options, private pay is an option. Medicaid's an option if you can financially qualify, and we'll talk about that. Then there's long-term care insurance. That is an option too. That's another spoke in the wheel. However, a lot of people can't afford, I mean, I like long-term care insurance if somebody has assets to protect, and I think it's a very responsible thing to do. But a lot of times people can't afford the premiums. And long-term care insurance is medically underwritten, which means if I apply, they're going to look into my health history. Do I have any chronic conditions? They'll look at my medical record, et cetera. And typically, you only can get long-term care insurance, I think, up till age 80, even if you're running marathons. That they after a certain age, you can't get it even if you're in excellent health. But long-term care insurance, a good policy pays for care at home, pays for assisted living, and also would pay for a nursing home and whatever your daily rate was. In Massachusetts, if you have at least $125 a day that will pay for 2 years, the government, local Massachusetts government, will never put a lien on your house. We call that lien buster insurance. So you have to check with your attorneys in your state to see if there's any lien buster insurance. Okay, next slide, please. I always say the care drives the legal plan. You have to look at how somebody's doing in their spouse. How's their health? Do they have any morbidity issues, meaning they have a high risk for long-term care? Or is there a mortality at issue? Do they really, are they under hospice and we really just need to avoid probate? I'm really not concerned about long-term care because they have really an acute mortality issue. So we always want to identify appropriate levels of care for people. Can they get help at home? Do they have to private pay? Should we go through elder services? And you all have elder services in your area. Would they be better served in an independent living facility or an assisted living facility? How are you going to pay for it? Or, God forbid, do they need a skilled nursing facility? Sometimes people need a nursing home because that's the skill level, that's the kind of care that they need. And in my experience, if somebody really needs a nursing home, we want to try to find a good nursing home, a highly rated nursing home. But we want to be honest about it and say they really don't. Assisted living really is not the best place for them. They actually will get better care at a skilled nursing facility. So all these things come to mind. And I always think that care issues would always drive any legal plan. All right, next slide, please. So community Medicaid. This is a tough topic because there's 50 Medicaid programs with all 50 states. But I'm going to give you some broad. Community Medicaid means I want to try to get a benefit program at home. It's not for a nursing home. Traditionally, there's clinical qualifications, and I mentioned those. It's typically the same clinical qualification of a nursing home that, hey, I need help with 2 out of 6 of my activities of daily living. My goodness, the most common one is I need help with the shower, bathing, and I need help getting dressed. Maybe I can transfer myself. Maybe I use a walker. Maybe I transfer into a wheelchair. I can ambulate, or I can feed myself, and I can toilet myself. But I really need help bathing and dressing. Those are the 2 big ones. But again, my client that has ALS needs help with all 6 activities of daily living. So there must be a clinical qualification. Traditionally in my area, they call it the frail elder program. Somebody who needs help with their personal care. And that's a clinical qualification. Next slide. There's also financial qualifications. Anytime we're dealing with the government, whether it's the state government, under these community Medicaid programs, the federal government, since they chip in 50% of the cost and the states chip in 50%, the federal government has a say in this. So does the state. But the federal government sets the rules. Typically, the person must clinically qualify, but also they must have limited assets. And those assets are usually set at $2,000 or $3,000. And the primary home doesn't count as an asset. So somebody could have a house, but very limited financial assets. They need help with care. And the next thing usually the government looks at is what is their monthly income. And again, in my state, the frail elders income $2,982 a month or less. Now, I just read something that the average Social Security payment is about $2,071 a month. So most seniors are on a limited income. They may have Social Security, they may have a small pension, but as long as they add up to about $2,800 a month or less, then the program could be considered. But again, you have to check with your local state. So I always want you to think about this because sometimes these community Medicaid programs can help keep people at home. Traditionally, they have like a asset limit for the well spouse. Like if the spouse who needed care can only have 2,000 in the name, the well spouse, there's an asset limit. Usually in my state, it's about 162,000 and the primary house doesn't count. Some states have a 5-year look back for the community programs. Massachusetts does not currently, but I wouldn't be surprised if one is instituted in the future because the federal government's putting a lot of pressure on the states. So typically for programs at home, there wasn't a 5-year look back, unlike a nursing home for Medicaid programs. But this seems all states are a little different. There is not currently a look back in my state, but that could change. So we always want you to check with your local elder law attorney. Next slide, please. Veterans. So veterans have some great benefits. I have a lot of respect for the veterans and for the programs they have. They're not easy to navigate, right? But I do have a lot of respect. One of them is called the Aid and Attendance Program, and that's where there's care dollars giving to a veteran or their surviving spouse. They had to serve during a wartime period and had 90 days active service. And traditionally, the veterans have a 3-year look back. So if assets were transferred, like for instance, to an irrevocable trust, that could disqualify somebody for 3 years for the veterans program. But look at the benefits. My goodness, if I'm a veteran, I could potentially get $2,424 a month to help pay for care at home or assisted living for me. What if I'm a surviving spouse of a veteran? It's about $1,500 a month. So there's some really good programs. Traditionally, the local veterans agent can help you with these programs. This is one. This is called the Aid and Attendance. There's another program called a home care program for veterans. And the home care program helps pay for help at home health aides through agencies that the veterans approve. I have in my home state, there's some great home care veterans programs which pay for about 14 hours a week of help. So sometimes that's the difference that's all the difference in the world to be able to keep somebody at home and keep them safe and not have the caregiver get worn out. Also, a lot of these veterans programs will also pay for somebody to go to assisted living. Strike that, to go to adult day health. So if I want a veteran to go to an adult day health center, which is typically private pay, the veterans typically will pay for that. So some really good programs that I want you to think about for veterans and their surviving spouses. Next slide, please. So this is God forbid a loved one needs a nursing home. These are the generic qualifications. The nursing home resident can only have 2,000 in assets. Typically, that's understandable. And typically, the spouse at home can have about 162,000 of financial countable assets. and the home is exempt. The primary house is exempt. So the spouse at home can have an automobile, and then they're able to keep income. And sometimes the spouse that's at home income, if it's a lot lower than the nursing home spouse, there's a formula for income to be moved over to the well spouse at home. So, so there are financial qualifications. Typically, elder law attorneys can help protect assets for a spouse at home because the laws are structured very favorable for a married couple. And then the next slide, please. If I'm single or widowed, I'm considered a single person, then I can typically in most states I only can have 2,000 in assets, and all my other things are countable. There are some exceptions, like if I had an adult child caregiver that lived with me and helped keep me home, and they were there at least for 2 years. In Massachusetts, anyways, the adult child is rewarded, and the house can be deeded to them. It is a federal law, so we'd have to have you check with each state, but they tend to reward the caregiver child that lives in the home. There's also disabled children. If I have a disabled child, the law exempts assets for a disabled child, and they don't have to live with you. And there's no look back to that. And then if I had a sibling on the deed and they lived in the home, traditionally the home doesn't count. So there are some exceptions, but generally it's a 5-year look back. Hopefully, if I'm single or widowed, if I wanted to protect my home, I saw an elder law attorney and I got the advice, and I took steps to do that, to start the 5-year look back. So next slide. And that's it. We did it. It's never too early or too late to do proper estate and financial planning. Hope this was helpful to everyone. I so appreciate your participation in being here. So thanks so much. Stay well.